Hello, everybody. I'm Pete Weatherby from Garden Court North, and I'm very pleased to be the chair of this event, Descent into Authoritarianism, the Rajiv Menon KC case. It's sponsored by Garden Court North, Garden Court Chambers London, One Pump Court, and Nexus Chambers, and sponsored by the firms Bat Murphy's, Bindmans, Dayton Pierce Glynn, Bernberg Pierce, ITN Solicitors, Robert Lazars, Hodge Jones and Allen, and Kelly's. I'm pleased to see the enormous concern about this case, evidenced by the fact that we have had about 1,200 people register for this event, which is far more than any event that I've ever had the pleasure to chair. For the first time ever in this jurisdiction, a lawyer is facing criminal trial for what he said in his closing speech to a jury. Wholly unprecedented here, but in my experience, not uncommon in certain other jurisdictions, authoritarian ones, as I'll mention in a moment. It represents a very dark turn for the rule of law here. In a few minutes, I'm going to introduce a stellar panel of speakers, including icons of the bar and representatives of wider civil society. This is a public event, and the comments made by individuals are their own, rather than the chambers and firms who sponsored the event or anyone else, including Rajiv Menon. Please feel free to use social media, and we intend to record and publish the event after it's gone out live. So what's it all about? Rajiv Menon is a senior barrister at Garden Court Chambers who's appeared in numerous high-profile cases and is highly respected across the bar and, as far as I'm aware, by the judiciary generally. In the recent Filton trial, prosecuting counsel complained to the judge that Rajiv was in contempt of court, primarily because he told the jury about jury equity in his closing speech and had gone against the judge's rulings. The judge had not interrupted Rajiv's speech, as sometimes occurs, and of course, as is the case in all trials, the judge had the final say in summing up. Whatever Rajiv did or did not do, the trial continued. The jury was not discharged, and they delivered not guilty verdicts on some charges and were unable to reach verdicts on others. Subsequently, the remaining charges went to retrial. Objectively, whatever happened, the trial process was not unduly affected. It's not uncommon for a judge to take issue with something said in a jury speech. Invariably, it's resolved before the jury at the time. In theory, if it was not rectifiable in the process itself, the judge could discharge the jury, wasted costs could be ordered, a reference to the regulator, the BSB, could be made. None of that here. Resort to criminal prosecution is wholly extraordinary and unprecedented. You can read Rajiv's speech online. It is as forthright as one would expect from counsel doing their job properly. It's not for me to analyse the issues here, but Rajiv denies asking the jury to apply the principle of jury equity, and he asserts that he told the jury that they should follow the judge's legal directions. What he did do is remind the jury of their independence and that those legal directions included that they were the sole arbiters of the facts. I cannot recall a single jury trial in my 35 years at the bar where I have not reminded the jury of the same, albeit in ways tailored to the particular case. If you do read Rajiv's speech, you may also be struck by the fact that he plainly did not intend to stray over any forbidden boundaries. In my view, that is important to any decision as to whether to pursue a lawyer for their actions in defending their client, irrespective of the strict legal position. How could it possibly be in the public interest to pursue a prosecution against a lawyer if they had no intention to step outside of the law? Subsequently, the judge referred Rajiv to the High Court to decide what action to take in such a way that the Court of Appeal ruled unlawful. Undeterred, the judge has now referred the matter a second time to a presiding judge who has instituted contempt proceedings and listed it for trial before Ms. Justice Chima Grubb next Tuesday and Wednesday. I've already noted the matters that the judge chose not to do, including discharging the jury and reference to the Bar Standards Board. But he also chose not to refer the matter to the Attorney General an independent law officer. Why not? Rajiv's lawyers have submitted a further procedural appeal. As we've opened this event tonight, the breaking news is that the Court of Appeal have indicated that they are not able to hear the appeal before the trial date of Tuesday and Wednesday next week. But nevertheless, the trial judge has indicated that she intends to go ahead even though there is a pending appeal and an appeal as of right. Again, there are many firsts in this case, but that one is a first on me as well. Whatever the outcome, the question remains, if the judge considered that these facts merited the first ever criminal trial for contempt relating to a barrister's closing speech, why did he not refer it to the Attorney General? Both the judge involved and the judge who is to try Rajiv appeared in cases with him when they were at the bar, and he has appeared in cases before them both as judges. There is no evidence of animus towards Rajiv of which I am aware, but the appearance of this is obvious and awful. The independence of the judiciary and the independence of the bar are both vital to the rule of law. If there was a case to answer, so serious that the public interest pointed towards prosecution, it should obviously have been referred to the Attorney General, and I cannot begin to imagine why the judge thought otherwise. Before I hand over to others, I referred earlier to the criminalisation of defence lawyers in other jurisdictions. Despite international conventions to protect lawyers, prosecuting them is a tactic of choice in authoritarian countries with a poor adherence to the rule of law. I'll give you just one example. In 2019, I attended part of the trial of Selahattin Demirtas, leader of the HDP, the third largest party in Turkey, and he was a prospective presidential candidate. I attended on behalf of the Bar Human Rights Committee. The trial occurred in the aftermath of the 2016 alleged coup attempt, in response to which the state had arbitrarily dismissed a quarter of its own judges. The European Court of Human Rights was to find that the detention of Mr. Demirtas was a rare breach of Article 18, amongst others, meaning that it was politically motivated. But on the same trip, it came to my attention that one of the defence lawyers, who had also appeared in a number of trials criminalising journalists who criticised the president, was himself on trial the very next day for the crime of giving a newspaper interview where he questioned the independence of the judiciary. Is this where we are heading? The report of that case is on the Bar Human Rights Committee website, together with many others, chronicling the criminalisation of lawyers in other countries. The criminalisation of defence lawyers is not only an attack on them personally, but an attack on the rule of law itself. It will necessarily have a chilling effect and thereby undermine the independence of lawyers and the protection of the fundamental constitutional rights of their clients. We have been warned. I'm now going to introduce the speakers in no particular order, save that I know some of them have to get off to other events. We've asked the speakers to keep to strict time limits, so please do, given that there are so many of them. I'm very pleased that there are so many of them. So I'm going to start, if I may, with Baroness Shami Chakrabarti, the former Director of Liberty and a former Shadow Attorney General. Shami, please.
Thank you, Pete. Friends, it's a huge privilege to share this platform with so many lawyers and campaigners with whom I've shared common cause over many years and who I certainly share my most core values with. I'm just sad that we're here for this reason. The late, great Tom Bingham gave us the clearest modern exposition of the rule of law. He set out 8 principles to give content to this phrase, the rule of law, to which Pete has already referred. The 5th rule, you may remember, was that the rule of law should protect fundamental human rights. That, of course, includes the right to a fair trial and the representation of your choice. And the 7th principle is that courts should be fair. It's my view that it's crystal clear that both of those principles, those golden rules that are part of the rule of law, have been violated, graphically violated in this case for everyone to see. It seems to me that we're in such polarized times at the moment. The things we once took for granted about freedom, about a liberal consensus around fair play, are now in contention. Now, in recent years, we've seen so many attacks on civil liberties, on lawyers, on judges, on the rule of law. But normally, they've come from the executive. I'm afraid we've seen governments increasingly restrict freedom to protest, even peaceful protest. We've seen, I'm sad to say, even from a Labour government recently, hopefully this will change now, attempts to further restrict the right to jury trial. We saw from the last Conservative government an attempt to legislate to overturn the Supreme Court's decision on the facts of the case, to legislate that Rwanda would be deemed safe, not just in the moment and contrary to the evidence, but for all time. As I say, these are great threats to freedom and the rule of law, but they came from the executive. How more difficult, unsettling, and delicate to handle when the threats come from within the judiciary itself. Now, I'm not someone who routinely criticises judges. I think that is a very delicate and dangerous thing to do when judges themselves, like lawyers and journalists and others who care about human rights, are so often under threat. But judges are human, and it is my view that judges have behaved capriciously in this case in a very chilling manner. Rajiv Menon is a very, very fine advocate who's devoted his life not to defending oligarchs and other wealthy and powerful people, there's nothing wrong with that, but has devoted his career to public service and to causes of profound injustice, human rights violations, actions against abuses of power, and so on. And so it is particularly unpleasant to watch his treatment at the hands of a part of our judiciary. I have not spoken about his case before for fear of doing anything to prejudice the appropriate appeal process and his legal strategy. But I think we're now approaching a moment where, under strict advice and guidance from Rajiv and his lawyers, we may need to broaden this campaign and indeed make it a campaign without at all prejudicing the trials and appeals that need to perhaps come first. But people have a right to know what is being done, what is being done to the right to a fair trial when lawyers, court advocates are penalised for doing their job and representing their clients. That's what's at stake here. So, as I say, I want to hope and believe that the appeals to come will resolve this issue and we can then resign this chapter to the history books. A terrible, capricious mistake by a trial judge rectified on appeal. That is what I hope the outcome will be and will be soon. But if that does not happen, then we have to go further. And for my own part, I believe that if the judiciary do not stand up for the rule of law, including an advocate's right and responsibility to make a jury speech to the best of his ability in the interests of his clients, then we will have to return to Parliament with this, as happened with the postmasters not so long ago, and that injustice will have to be rectified. There is a Courts and Tribunals Bill. I hope it will be drastically changed under the new administration to remove the parts restricting jury trial. But nonetheless, that bill has broad enough scope to legislate clearly, unequivocally, for an advocate's right and responsibility to speak freely in defence of his clients before a jury. And if necessary, I personally will bring an amendment to that bill or to any other appropriate vehicle to entrench this principle and indeed to make it retrospective. Unusual, sad that we might have to do that, but I personally am prepared to do that if that's what it takes. In the meantime, I send my respect, my solidarity, my solace to Rajiv and his team. And I'm so glad that we're all here. We're all here to stand up, be counted, and say this is a line in the sand. There is no rule of law. There is no right to a fair trial if lawyers are to be treated in this way.
Thank you very much indeed, Shami. Powerful words indeed. Next, we have Lord Hendy, King's Counsel, a leading, very well-known trade union law silk and member of the House of Lords. John, please.
Thank you, Pete. Like Shami, I feel a very great honour in sharing this platform with so many esteemed colleagues in defence and support of our very esteemed colleague, Rajiv Menon KC. Let me offer my apologies. I'm one of those who have to go to another event very shortly. I shall be short. Anybody who knows anything about my practice knows that what I know about criminal law could be written on the back of a very small postage stamp. But I do have some experience of contempt of court proceedings. Over the last 39 years, I've represented many unions and union officers who've been brought before the courts on contempt charges of defying injunctions for taking industrial action and so on. My role in this campaign has essentially been to try and galvanize support amongst the trade unions, and I'm very pleased to say that all the unions which I've so far contacted have written saying that they support the campaign and the statement that has been issued so far. I've copied all those to Rajiv. I'm afraid I haven't had time because I've been in the House of Lords today to count them, but I think we've got half a dozen so far, Rajiv, and I'm seeing the president of the TUC at a function later on this evening when I'm going to see what can be done vis-a-vis the TUC. So there is massive support, as indeed the attendance at this seminar shows. But the question, of course, is what is the object of the campaign, and what can the campaign legitimately seek and ask people to sign up to and demand? Because we have to be very careful not to fall into the trap of it being said that we in some way have tried to influence the court proceedings. But it does seem to me that it's not that difficult for a campaign statement to express concern about the two principles involved here. One, the freedom and indeed duty of defence counsel in criminal proceedings to make the best speech that they can in defence of their client, and two, that juries must decide the cases according to their conscience. And if we express that concern without reflecting on the particular circumstances of Rajiv's case, I can't see that we can be criticised for that. I'm sure there are people better qualified than I am to draft such a statement, but I do think that that's what we need, is to do that. Because I understand that there's some reluctance in some quarters to express support for Rajiv's position, for fear that it will in some way prejudice the forthcoming hearing next week. So that's my contribution, really, is to say, look, there is a way around this to campaign in the way that I suggest. I'm particularly concerned that the Bar Council, who've already made a statement through Kirsty Brimlow, the chair of the Bar, prior to the Court of Appeal hearing a week or so ago, I'm particularly concerned that Kirsty and the Bar Council should make some sort of a statement before the High Court proceedings next week. I wait to see. There are people on this panel who are better connected than I am to seek that support. But again, it does seem to me that there's no obstacle to the Bar Council saying we are very concerned that the freedom and duty of defence counsel to make whatever they think is the appropriate speech in defence of their counsel, so as long as they stick within the law, is at risk here, and that the principle that juries decide cases according to their own conscience, as has been the law for, as I understand it, for 300 years or so, is a paramount obligation. So I'm afraid that's probably all I can contribute, Pete, to this evening's event. Thanks for listening.
Thanks very much, John. Thanks very much for your contribution. Next, I'm going to call on Real Carmi Jones, King's Counsel, who is the current chair of the Criminal Bar Association. I'm very particularly pleased that you've been able to make it. I know you had to go off quite early, Real, but thank you very much for making it. So over to you, please.
No, thank you very much for inviting me. As you say, I'm the chair of the Criminal Bar Association, and as such, I represent criminal barristers in England and Wales. And we have all been closely following the developments in Rajiv's case. It is worrying to us, as Baroness Chakrabarti has said, how polarizing this issue has become. And it is a concern that it is starting to feel like it's about the politics of the subject matter of the trial, rather than the core principles of how a barrister represents his client. The CBA has received emails and messages from members with very different views, and I must recognize we represent them all. But I want to make it clear that I don't think that anyone, least of all Rajiv, disputes the principle that as barristers we are bound by the law and by rulings and orders made within the law by a trial judge. We have to remember that Rajiv has denied that he breached the judge's ruling deliberately or at all. And it's really important, as people liberally throw comment from the sidelines, it's important to remember and respect that this is still an unproven allegation against him. But our concern really comes from the number of tales of barristers across different parts of the country that we have heard of barristers changing their speeches or being told to change them, including in cases where no direction has been given by a judge. And that really can't be ignored, because people at the criminal bar have become uncertain and scared of what they can and can't say, scared that somehow they might be at the end of a trial where they have faithfully represented their client, themselves be facing a charge of criminal contempt, and also through some unknown and novel procedure. Because what is really an enormous concern is how this is impacting how criminal barristers feel able to do their job, and how well they do it, and how well an innocent until proven guilty defendant is represented. Something that really troubles us here is the rather unusual process which has been followed, which Pete touched on in his opening comments. I'm not going to go through all the steps that may have been done or the things that could have been done so as to prevent this going so far. But as Pete Weatherby, King's Counsel, said at the outset, it's common for judges to stop speeches when they feel that they've digressed or gone too far. It's far from unusual to ask defense counsel in a case to withdraw what they've said in front of a jury, or even at that stage to give a direction to the jury. At the end of a speech, to give a really firm direction to a jury. It's also possible, if a heinous contempt has occurred, for the jury to be discharged, for another firm direction to be given during a summing up. And the usual expectation would be for a wasted costs order, perhaps, or a regulatory process, reporting the said barrister to the BSB, which might be thought to be far more proportionate than what has in fact followed. But the process followed has been a summary process, which is intrinsically designed to deal with things like where a defendant is swearing at a judge from the dock so that the judge can take swift action then and there to protect the integrity of an ongoing case. But in Rajiv's case, the trial is over. The offence complained of took place months ago. There's no urgency. So why not refer the case in the usual way to the Attorney General, who would be best placed to independently consider whether it's in the public interest to initiate proceedings for contempt of court. And so the issue has, over the last months, grown to be one of fundamental importance to the criminal bar, because it appears to be interfering with the barrister's role to represent their client's case fearlessly and as they consider appropriate, as long as they remain within the boundaries of the law. And in so doing, we suggest it's interfering with the rights of the citizen, the client, who's entitled to expect their barrister to present their case, their defence, warts and all, and to speak out in their favour against the accusations they face. And all this has the potential to lead to a significant loss of trust in the system, in the criminal justice system as a whole. Before I finish, I want to say something personal to Rajiv. Rajiv, we don't know each other very well, but we spent quite a while knocking around at the same cases, but on different sides, me a prosecutor, you a defender, when we were both much younger and very much more junior. I do remember poring over huge jury bundles and trying to agree them with you. And you have always been and always were an absolute gent. You were one of the nice ones, one of the good ones. And so it was no surprise when you were awarded Silk a few years early for most criminal practitioners and a few years before me. It was well-deserved then, and it is well-deserved now. As you know, the Criminal Bar Association are following the case. We're going to continue to do so. And we're incredibly grateful to Garden Court and others for their engagement with us, for inviting us to be present at these important meetings and for keeping us informed. Now, a moment ago, the Bar Council's role was raised, and what their actions are in relation to the case was raised. And in fact, I spoke to Kirsty Brimelow earlier today, and just before the meeting convened, sent her a message because she'd said she was sad that she wasn't able to be here. Can I just say that she has, whilst we were speaking, sent me a message saying, asking me to read this from her. She says, as chair of the Bar Council, Kirsty Brimelow KC says, I'm in contact with Rajiv's leading counsel. I spoke in some detail with Joshua Rosenberg about the case on his podcast on May 15th, and I made a statement on May 13th following the Court of Appeal ruling. I and the Bar Council continue to follow the proceedings and the type of proceedings with concern. Sarah Kavanagh of the Bar Council is attending this meeting to observe. There will also be representatives of the Bar Council observing the hearing if it goes ahead on the 28th and 29th of July. There will also be representatives of the CBA at the hearing if it goes ahead on the 28th and 29th of July. So I can't say we look forward to seeing you there, but we will see you there.
Real, thank you very much indeed. That was really helpful. Thanks very much. And thanks very much for reading out Kirsty's message. Kirsty was invited, but obviously she's very busy, so it's good to have a message from her. We've got some further messages which I'll read later. I'm going to move swiftly on, if I may, to Keir Monteith, King's Counsel, a Silk at Garden Court, an honorary professor of law at Manchester University, a part-time judge and a judicial tutor. Keir, please, over to you.
I'm proud to be able to speak in support of Rajiv Menon, King's Counsel, a phenomenal lawyer, a member of Garden Court Chambers and a friend. The first time I heard his powerful advocacy was when he spoke at Essex University in the 90s. Brilliant then, as he is brilliant now. And over the decades, he has made groundbreaking contributions to the world of law and beyond through representing clients, making submissions to inquiries, being joint head of Garden Court Chambers, and administering our special fund that has provided over £1 million to good causes. I have no hesitation in supporting him in his hour of need. Indeed, I'm one of thousands who stand shoulder to shoulder with Rajiv. And on this meeting, over 1,000 people registered, and I can see on the counter we are way beyond 700 people listening to what the panel says. And we know that there is phenomenal, in capitals, in bold, underlined, phenomenal solidarity and support across the whole of society, from the legal profession to NGOs to campaign groups, with a kaleidoscope of support from the big hitters and, as you've just heard, our professional bodies. And if your organisation or you has not expressed that support, make sure that they do so now. Because solidarity is expressing that support now. Solidarity is being visible now. Solidarity is a bond that permanently protects us now and in the future. I am Rajiv Menon KC. You are Rajiv Menon KC. We are all Rajiv Menon KC. And this expression and act of solidarity is for advocates just starting out in their careers who see injustice and speak up. This expression and act of solidarity is for advocates who have advanced through the legal system's hierarchy, who see injustice and speak up. And this expression and act of solidarity is for advocates who are feeling the pressure, feeling vulnerable, feeling bullied. But when they see injustice, they still speak up. And none of us, in speaking truth to power, should ever have to face the prospect of being locked up in jail for what we say in a closing speech, as it creates a chilling effect, which is already happening on all advocates operating in the criminal courts. And it's never underlined in bold, in capitals. It's never happened before for good reason. No one else's terms and conditions of employment gives the boss the power to send them to prison for allegedly breaking the rules. No one. In this case, the judge made an order, quote, "The jury are not to be informed that a judge may not direct the jury to convict," end quote. In 30 years plus at the criminal bar, I have never been aware of that type of direction ever being made. Indeed, I have heard this type of speech numerous times by many lawyers, and such references help to impress upon the jury the importance of their task by reference to what has become a constitutional legal right of jury independence. Bushell's case, as it is known, represents a cornerstone of our justice system that has been with us for hundreds of years. And that cornerstone should be jealously guarded by us all. And we're doing that now. We are all with you, Rajiv. We have your back. Please all stand and say and post, "I am Rajiv Menon KC." Please continue to speak truth to power. Please sign the petition.
Thank you very much, Keir. Thank you very much. Very powerful. We are slightly slipping time, so can I just remind everybody to do their best to keep to their times. Akiko Hart is the next speaker. Akiko is the director of Liberty and a professor. So over to you, Akiko.
Thank you so much. It's really good to be here today with so many friends and allies, and many of my points have already been covered. The wider context here, of course, is the authoritarian crackdown on protest over the last 5 years. It's been well documented, from the Policing Act to the Public Order Act to the Crime and Policing Act, all potentially to be reviewed in the long-awaited McDonald Review. But as well as the increasingly restrictive legal framework around protest, Liberty has been concerned about the increasing trend for individual judges making draconian case management decisions in protest trials, leaving defendants unable to properly mount a defence. These case management decisions have led to what amounts to a crisis of free speech in the courtroom, with barristers prevented from being able to properly defend their clients and defendants unable to explain to juries the conscientious motivations behind their actions. Barring counsel from telling the jury about the principle of jury equity is a new and deeply concerning development. The fundamental rights of jury equity must be protected. The entire criminal justice system rests on the role of the jury in serious cases to decide the guilt of defendants rather than professional judges. And contempt proceedings like these, or the threat of them, are stopping people being properly represented at criminal trials. Now, there is much more that I could say, and much more that I cannot say. Liberty is in contact with Rajiv's team. But I'm really aware that for all panelists, there is so much that we cannot say. And you may ask, well, what is the purpose of this webinar? Because there is so much we can't talk about. And to my mind, the purpose of this webinar is to come together as a legal community, as campaigners, as people who believe in the rule of law and the constitutional importance of jury independence, to express our deep concern at this development. I'm incredibly grateful for the conveners, the incredibly esteemed speakers, and the audience today for creating the space to have this conversation, but also for people's courage in speaking out today, people's care and courage. And if I zoom out a little bit, we're going to need a lot more courage in the years to come. Thank you.
Akiko, thank you very much for that. The next speaker hardly needs an introduction. Some people would call him a national treasure. He's a silk at Nexus Chambers. I know him as the devil incarnate because Michael Mansfield KC had a file that's just come out in the undercover policing inquiry. And the undercover policing file had that as his name on the front of it. Michael, with that introduction, please, can I hand over to you?
How can I follow that? Yes, I was obviously going to mention, I don't want to sound like John Cleese in a shoebox, but it does, that devil incarnate description, which was on the file, just a footnote. It's interesting how the file has suddenly gone missing at the very, well, not missing, it's been destroyed. But it illustrates the situation. The file was created in 1976, and Rajiv, it's a message to you from me. You know, I've stood by you in all sorts of situations. We stood together through many inquiries of the same issues that have arisen. And so we're right with you on this. But I wanted to say it's dominated my career. And I think probably no one in this panel or even watching is probably of such an age as I am. I was called in 1967. So I'm just about to reach the 60th year of practice. But a large number of those years, I was conscious of the fact there's probably a file on me. I was conscious of that fact, even though I didn't know until recently that there was such a file, placing me in this incarnate situation. However, what it demonstrates to me is what I was told repeatedly on my call in 1967. I've still got the pamphlet with me in this rather disheveled looking office. A pamphlet which was written by one of the great lawyers of a previous age, but the message was simple. The duty of the advocate was being given to us on the call to the bar. And the duty of the advocate are the words that have been repeated so many times of being fearless and independent. Absolutely important for, as Shami said right at the beginning, if we're going to have a rule of law which is being dismantled as I speak by nations and by governments regularly, is being dismissed, the only people left to defend the rule of law will be lawyers, not politicians. It's going to be those of us who stood up for that from virtually the Second World War onwards with the Court of Human Rights and so on. But I've been aware that I've probably engendered hostility by taking this position of asking unpalatable questions, sometimes to very unpalatable witnesses, but they have to be asked. I'm aware of the unspoken, sometimes in the early days, with the names of judges I'm not going to name, but they are very well known at the time, who were clearly hostile to the position being adopted by myself and a number of others, but there were few at the time. And effectively, what I want to say, Rajiv, is I'm still here. I've done what I felt was necessary for the bar, and absolutely more necessary now. We have a situation in which juries themselves are being cut, not for economic reasons, we know that. Juries are being cut essentially for political reasons, because we're not introducing the politics, the government is. The descent into authoritarianism is being promoted by governments, and now we have a judiciary. It seems to me, well, at least this particular representative of the judiciary, who are colluding with a situation in which the very defenders of the faith, the defenders of the rule of law, are going to feel they can't do it. And it's already happening. The chilling effect, as one judge proclaimed in relation to one of the Palestine cases. So for me, Rajiv, you stand firm, and when you look round, there are going to be thousands behind you. Good luck.
Thank you very much, Michael. I'm going to move on to another household name, Gareth Pearce, in a moment. But can I just first read out a message? Helena Kennedy was supposed to be with us tonight, but unfortunately she's not been able to make it. So she sent a very powerful message. So I'm just going to read that out. And I'm literally reading out. I am very alarmed that a barrister is being prosecuted for something as serious as contempt for reminding a jury of the founding principle that juries are the judges of the facts in a criminal case. Judges are there to determine matters of law. Independent lawyers are as important to the rule of law as independent judges. In my view, it is wrong for a judge to close down the introduction of evidence that might put a different complexion on what would otherwise be criminal acts. Context is vitally important in a criminal case, as I have always believed and argued. The context of actions can affect the state of mind of each of those who are accused and a jury's understanding. I regret to say that I think there's an increasing silence within large sections of the British establishment over the conduct of the Israeli government towards Palestinians for fear of being accused of anti-Semitism. It happens in Parliament and it happens in our courts. Grievous atrocity crimes were committed by Hamas on the 7th of October, but a multitude of war crimes have now been committed by the Israeli government. That is not irrelevant. This prosecution is another assault upon our justice system and ought to be resisted. Baroness Helena Kennedy, LT, KC. Gareth, solicitor, founding partner of Bernberg Pearce, and as I say, a household name. Can I hand over to you, please?
The enduring advice of Howard Zinn, an American civil rights activist, is still good. You can't be neutral on a moving train. If you see historic and social events are already moving in harmful directions. You can't choose to be neutral. If you do, then you're accepting them. Right now, we can see frightening indications of movement in our criminal trial structure, affecting institutions whose roles have been hitherto understood to be stable and immovable: the jury, the advocate, and the judge. That they are less certain now than we believed is in itself terrifying. First, the jury. Until a week or so ago, and but for an accidental change of the administration of this country, there was a legislative commitment to abolish juries as the tribunal of fact for all crimes where the penalty was less than 3 years. But whatever the tribunal, extraordinarily, legislatures, and then, of course, in turn, prosecutors and judges, directly limit, in particular crimes, what a jury can be told about a defendant's motivation. We've always understood that to be a central, key, important aspect of a criminal trial. Second, the advocate. That an advocate is facing a criminal accusation for his closing speech triggers not only the highest anxiety for him, but that it is for a defense advocate, and it is the first time, who is to be charged, necessarily triggers anger at the selectivity and differentiation in the face of a history of never a charge or trial for prosecution speeches, even when it ridiculed a defendant of his right ability to produce a alibi witness, which at the same time the prosecutor was concealing, or depriving the defense of knowing forensic scientists' evidence, data of exculpatory evidence, refusing its disclosure. 3, the judge. To observe that non-existent procedures have been invoked to prosecute an advocate and existing procedures not followed, and to observe that they are being embarked upon again, is to observe extraordinarily the entry into testing of the limits of judicial power. All of this is terrifying. All of it is abnormal. The train is moving. To ignore that, to be neutral, is not what we should do.
Gareth, thank you very much indeed. Fantastically powerful words. Can I move next to Blinna Negralla KC, leading Silk at Matrix, specializing domestically in protest cases and international human rights law, which very much includes the defense of lawyers. Blinna.
Thanks, Pete, and good evening all. It's wonderful to see so many people here this evening, including so many giants of the legal world, though humbling to follow the legend that is Gareth Peirce. The exhortation made to the jury by William Penn in the Bushell case, establishing the right of juries to acquit according to their conscience, as cited by Rajiv in the closing speech for which he is being prosecuted. You are Englishmen, mind your privilege, give not away your right. That exhortation, although almost 600 years old, could not be more apt or topical at the present time, for Englishmen and for us other mortals. Rajiv's utterly unprecedented and extraordinary prosecution cannot be divorced from its immediate and wider context of the onslaught on fundamental rights that we're witnessing currently. First, the context of the extreme and authoritarian crackdown on speech which is happening in this country. One of the particular hallmarks of this crackdown is the exposure of principled individuals, of people of conscience, to the risk of extreme sanction and penalty for alleged speech-relating offending, including for holding placards denouncing what continues to be a live-streamed genocide in Gaza, for wearing badges, for reciting poems, and now for an impassioned jury speech given by a leading, brilliant criminal silk. Second, the prosecution also cannot be divorced from the broader context of the assault on jury trials, which has already been mentioned, the fundamental constitutional right of the public to be judged by their peers. A principle so fundamental as to be described by Lord Devlin as the lamp that shows that freedom lives, as repeatedly quoted in criminal trials the length and breadth of the country. The flame of that lamp is at extreme risk. The purported rationale given for the proposed reforms that imperil it, that seek to curtail the right to trial by jury, which is that they are necessary to reduce the serious court backlog, has no merit and is contradicted on the evidence as repeatedly demonstrated. Another rationale for doing away with jury trials was raised in an utterly bone-chilling speech given a few days ago by one of the most powerful figures in the Trump administration, Stephen Miller. As so often in modern-day America, saying the quiet part out loud. Having asserted that appeals to civil liberties are but a tactic that, quote, must fall on deaf ears when the leftist protests that we are violating his rights. He called out the principle of jury equity, jury nullification in America, as a particular evil. And he urged states to stay the course and be completely unflinching in the pursuit of justice against these enemies of civilization. Those enemies of civilization apparently including those who would acquit in accordance with their conscience in the face of authoritarian laws and unjust prosecutions. As the saying goes, if you are not afraid right now, you are not paying attention. So, having begun with the words of an Englishman, I'll end with those of an Irishman. They are words that echo Penn's exhortation 600 years ago and Bushel's responding promise to hold firm to fundamental rights. And the words are from the Republic of Conscience, composed by Seamus Heaney to commemorate 25 years of Amnesty International and its work, including for prisoners of conscience. And it describes returning from an imagined Republic of Conscience, where radical democracy and human rights are practiced and respected. And it reminds us of the importance of freedom of speech and for speaking up for what is right. And Heaney says, I came back from that frugal republic with my two arms the one length, the customs woman having insisted my allowance was myself. The old man rose and gazed into my face and said that was official recognition, that I was now a dual citizen. He therefore desired me when I got home to consider myself a representative and to speak on their behalf in my own tongue. Their embassies, he said, were everywhere, but operated independently, and no ambassador would ever be relieved. Juries are the ambassadors of conscience, which is why they represent such a fundamental and critical safeguard against authoritarianism. We too, as human rights lawyers, are ambassadors of those rights. It is for us to try to ensure that the embassies of fundamental freedoms and conscience continue to operate in these troubling times, to continue to advocate for fairness, for what is right, without fear or favor. It is so reassuring and uplifting to hear so many and see so many of you here united in that aim, in solidarity and support of one of our finest, Rajiv Menon KC.
Linda, thank you very much. Again, extremely powerful words. Before I move on, I have one more message that I want to read out. And it's from Ed Fitzgerald, King's Counsel of Doughty Street, who again, yet another giant of our legal community. Unfortunately for us, he's currently abroad and unable to join us, but he sent, because he's so concerned, he sent the following message. Criminal defence lawyers who are at the coalface of the justice system must be able to defend their clients fearlessly without the threat of imprisonment from vague and unpredictable judicial procedures. It is an entirely novel and disturbing development for criminal contempt proceedings to be invoked against a barrister for words spoken during a speech made to a jury. Criminal barristers have a duty to zealously defend their clients, and it can never be in the interests of justice to deter them from doing so in accordance with their professional judgment by the threat of criminal sanctions. Ed Fitzgerald. I'm now going to move on to introduce Sarah Jane Hewitt, a junior barrister at Wampum Court, who regularly appears in cases where the chilling effect of prosecuting lawyers will bite hard. And I think, having heard from some of the greats of the legal community, it's massively important that we hear directly from those who are going to be most affected going forward. Sarah Jane.
Thank you so much. And yes, what a privilege to speak on this amazing panel of hard hitters, to which I bring a very junior voice. But I agree, I think junior voices are important in this conversation because there is a chilling effect as a result of what has happened to Rajiv, and it is impacting the way that those of us on the junior end are doing our jobs, those of us who are in the first few years of our practice, with the rest of our careers ahead of us, and perhaps without the buffer or cushion of experience. Now, you've heard that it's the sharp end of a building trend over the past few years, and there's some patterns in relation to representing protest clients in particular, various factors at play that can put us in difficult situations when it comes to closing speeches. There's ruling out of legal defences before trial. There's intense restrictions on defence evidence following the ruling out of those defences. And then the question is where that leaves you in closing speeches. There are developments with jury equity, and finally now this threat of contempt. A confluence of those factors features in almost every protest trial, but it's very difficult to know how they'll be dealt with ahead of time because they are dealt with wildly differently from court to court. And ruling out defences before the evidence, for example, over the years that has proliferated from court to court. And there's a fear of that sort of insidious mission creep following Rajiv's case. We're fearful of judges going, hang on, isn't there a thing about contempt and closing speeches? And on the other hand, you have defence counsel who know there is a trend, who are familiar with Rajiv's case and who are terrified. I echo what Real Carney Jones said, people are changing their speeches as a result. I tried to shop around for examples from my colleagues of them changing their speeches as a result of what's happened with Rajiv's case. There were too many to tell you in the time we have. Almost every one of my colleagues in chambers has had to contend with this, or has a case where either the spectre of contempt has been considered or raised, recently in non-protest cases as well as protest cases just in recent months. And the consequence is the defendants will not get fearless advocacy. They'll get a barrister who is anxious, uncertain, self-correcting, with one eye on the judge to try and gauge whether with any sentence they've gone too far, or whether they've been negligent to their client by not going far enough. But the reality is that the trial process is built to be adversarial. Defence counsel should be able to go as hard as their skill allows, and judges can direct the jury as robustly as necessary to correct them if they go too far. And as long as the question of innocence or guilt is ultimately left with the jury, then everyone has done their jobs. There's a quote in the case of Wang, with those of us who argue these cases will be familiar with, which I wanted to share with you, to the effect that the jury is an insurance that the criminal law will conform to the ordinary man's idea of what is fair and just. And it says that the executive needs to know that if it does anything to seriously disturb the conscience of the jury, then the jury will not be a party to the law's enforcement. And that is absolutely right. Juries do acquit if you give them a reason to do so, but for the system to work, barristers must be allowed to do their jobs. So solidarity to Rajiv, and thank you.
Thank you very much, Sarah Jane. Again, very powerful words, and extremely important to be heard. Next, we have Marcia Willis-Stewart KC, Managing Partner and a leading civil liberties and human rights solicitor at Bernberg Pierce, and somebody who has instructed Rajiv over many years. Marcia.
Well, this is really a message to Rajiv. Rajiv, I've spoken with a number of the Hillsborough families, and they wanted to convey and felt it really important to convey their support to you. We've heard a lot said about solidarity and community, but one family that you represented in particular said, well, you know, he's always fought for the ordinary people, and he fought for us to uncover the cover-up and to get truth. And so we should be standing by him. We need to stand by the fighter who fought for us. And so, Rajiv, I want to say to you, we and the Hillsborough family are your community. We stand by you. And in the words of Audre Lorde, without community, there is no liberation. Thank you.
Marcia, thank you very much indeed. And can I just add to that? I was speaking to a family member from Hillsborough this afternoon, and I know that I won't name check her because I won't embarrass her, but I know she's on this call, and I'm sure there are others too. Henry Blaxland, King's Counsel, a senior criminal silk at Garden Court Chambers, who of course has worked alongside Rajiv for many, many years. Henry, please. You're muted. There you go.
Yeah, hi. I've got just 3 short points. I'm not going to attempt to follow up the very powerful contributions which you've already heard from various people. The first is this: I'm a very good friend of Rajiv, as well as being a professional colleague, and it doesn't really need me to remind him just how much support there is for him. And it's very difficult to overstate the degree of anger there is at Garden Court Chambers about this, but also amongst other people that I speak to, and it extends far and wide. It extends to, Treasury Counsel. People are very, very concerned about this, and I think that that needs to be known. And my first point is this: people talk about the chilling effect of counsel in court and the content of their speeches. It's the chilling effect of being able to say what needs to be said about these proceedings, because everybody feels that there's a risk that if you step over a line, you're going to find yourself in the same position. So can I thank Pete for organising this meeting, because it's very important. And I particularly thank Real for coming along, because I think it's very important that the CBA and the Bar Council take a role. My second point is this: it's a point actually which has not been raised so far, and it's about the detail of this, but it's extremely important. What disturbs me most about this is the involvement of the prosecution. These proceedings were initiated by a submission being made that a criminal contempt proceedings should be initiated on the basis of a speech which was made, which involved no dishonesty, didn't involve anybody being misled, anything of that sort. And we talk about this as an unprecedented action. It's really quite extraordinary. And I have to say that it seems to me that this amounts to an abuse of prosecutorial power. It's not just that, it's been taken further. It's been positively pursued during the course of these proceedings. Of course, the point is this: if something's happened in the face of the court, it's for the judge to decide whether or not his or her order has in any way been ignored or disobeyed or whatever. The prosecution may raise concerns, but to positively advocate for criminal proceedings to be taken, it seems to me a line has been broken, overstepped. And in many ways, that's as concerning as everything else. And for those who are listening who are not lawyers, I think what needs to be understood is that the whole way that the system works is that there has to be trust between counsel. We have to be able to trust the prosecution to do the right thing. Prosecution have to be able to trust the defense to do the right thing. By initiating proceedings, particularly in the context of a case of this type, that trust has been fundamentally betrayed, in my view. It's been corroded. It leads to resentment, but also, of course, people aren't prepared to put their head above the parapet to say just how much they disagree with what has happened. My last point is this, and I think this may form an important part of the appeal proceedings, but it's very difficult to see, because of the extraordinary nature of these proceedings, how the appearance of bias can be avoided. I mean, let alone, just assume that everybody's going to try to do the right thing. But the appearance of bias in these circumstances is obvious to everybody. And actually, this may seem a bit of a strange thing to say, but actually it puts the trial judge in an extremely invidious position, because everybody's going to say, well, what's going on here? How on earth can these proceedings be free of the taint of bias? It's very difficult to see. Anyway, I'll just end by again repeating my support and solidarity with my dear friend Rajiv. You'll come good.
Thanks very much, Henry. Next, we have Raju Bhatt, solicitor, founding partner of Bat Murphy, and somebody who's known Rajiv for many years. Raju.
Thank you, Pete, and thank you, Mira, and everyone at Garden Court North for organising this important event. The title of this event, Descent into Authoritarianism, has a question mark after it. In my view, we don't need that question mark for all the reasons that other speakers have already given. It's not a question of whether or if we are in an age of authoritarianism. It's there in this country as we see elsewhere around the world. That is why it is all the more reassuring and so encouraging to see so many of us here today, ready to stand by and with Rajiv in the face of this wholly unjustified and unacceptable attack on him. We're talking about what needs to be said, and I will be forgiven if I do say what needs to be said in my view. We see here an attack not just on Rajiv for the way in which he sought to stand by his client in the face of the charges against her. It is also an attack on her for the way in which she sought to stand by the people of Palestine in the face of the onslaught against them, an onslaught in which our own government has been so complicit. And above all, as others more learned than me have already pointed out. It is also an attack on the jury system on which this client of Rajiv's, this particular defendant, sought to rely the right of juries to give their verdict according to their convictions. In my view, what we see appears to be a case of some within our judiciary so seemingly threatened by the reality with which they were confronted here that they felt they had to embark on this targeted attack, an attack born of the fear that a jury might just do the right thing in this case. As others have already pointed out, what Rajiv did here was nothing more and nothing less than the job he was required to do for his client, in accordance with his duties and pursuant to the rule of law. Indeed, it is worth saying that the rule of law has been flouted, not by Rajiv, but rather by two senior members of the judiciary who were all too ready to exceed their jurisdiction, as the Court of Appeal has already found. The trial judge, Mr. Justice Johnson, who triggered the attack on Rajiv in the first instance, and Lord Justice Edis, who was only too willing to run with the attack until he was stopped in his tracks by that Court of Appeal. We shall have to see whether the Court of Appeal, which hears the pending appeal before it on Rajiv's behalf, is prepared to stop other members of the judiciary who might want to find a way to continue this exercise in illegitimacy. In the meanwhile, I hope the message that goes out from this gathering is not only to Rajiv, that we stand by and with him in the face of this unprecedented attack on him, not just to the Court of Appeal, to let them know that we are watching to see whether they are prepared to uphold the rule of law by bringing this exercise in illegitimacy to an end. But the message also needs to go out to our new government, the demand that it is open to them to speak out loud and clear against what is nothing less than an abuse of the process, and therefore an abuse of the rule of law itself. And finally, a personal word to Rajiv. I have this to say to you, Rajiv. We are with you. I stand by you, and I will continue to stand by you as we move forward. Thank you all.
Thank you very much, Rajiv. Next we have Deb Coles, the CEO of Inquest, who works closely with many of the families that Rajiv has represented in inquiries and inquests. Deb?
Thanks, Pete. I'm really proud to speak alongside this panel and to show solidarity and support to Rajiv, who I've known for more than 30 years as a friend and colleague. Rajiv is also a trustee of Inquest, where his commitment to families affected by state-related deaths reflects the values that have shaped his work throughout his career. Across all of his work, including representing families after deaths in custody, his work on inquiries, Hillsborough, Grenfell, undercover policing, COVID, and Stephen Lawrence, I've seen his unwavering commitment to social justice, anti-racism, accountability, and upholding the rights of those whose voices are too often marginalised and ignored. Through Inquest's work, we have a unique understanding of how the state can operate at its very worst and the tactics that it uses. The institutional defensiveness, cover-ups, the systemic violence and neglect, the silencing and demonisation of victims, failures of accountability, and attempts to discredit those seeking truth and justice. Lawyers like Rajiv are vital because they understand not only the law, but the broader political and social context and the cases that he's involved in, and importantly, human consequences of injustice and abuses of state power. Whether acting in criminal trials, inquests, or supporting communities seeking redress, he understands that legal processes can be intimidating, complex, and profoundly unequal for those caught up in them. Rajiv brings legal expertise, but also humanity, a lawyer who listens, earns trust, and ensures those he represents feel heard and respected and confident that he will fearlessly hold people in power to account. He also understands that legal representation can do more than secure justice in individual cases, but help bring about wider accountability and legal and policy change, as the experience of the Hillsborough families with Hillsborough law has demonstrated. As we witness authoritarianism in action, the criminalization of protests, the threat to jury trials, attacks on human rights and the rule of law, and this dystopian prosecution, lawyers with Rajiv's independence and integrity are more important than ever. Communities and people rely on lawyers who are prepared to use the law to resist injustice, uphold human rights, and demand accountability. And an attack on Rajiv is an attack on all of us committed to speaking truth to power. Without such voices, abuses of power and injustice can go unchallenged, something we must resist at all costs. Thank you.
Thanks very much, Deb. Next, we have Matt Foote, a criminal and human rights law solicitor and legal commentator at Appeal, formerly of Bernberg Pearce. Matt, over to you, please.
Thank you, Pete. We live in very frightening times. In 2020, David Lammy said that jury trials are a fundamental part of our democratic settlement. And how far have we come in the last few years? The judge-led review that is a power grab by Leveson for judges to take over whole swathes of trials, but particularly protest trials. It's the fact, really, that there would not be any protest trial that would get a jury if those reforms came in. No longer would ordinary people be deciding if protesters are innocent or guilty. It would be the judge with their particular background and their particular race and all the things that all the prejudice that will come with them. So that's the most scary thing. But alongside that, over the last few years, has been the silencing of protesters in their trials as to why they are protesting at all, the motivation. Not allowed to hear that in the court, continuously judges censoring. And now we have the natural extension of that is the representative of the protester giving his speech, who's now being threatened with censored, but not just being threatened with censored, but with imprisonment. For what? For mentioning Bushel's case, probably the case of which we should all be proud, which says that the jury decide the verdict, not the judge. Just for mentioning this, he's threatened with going to prison. Now, I wanted to come back to the point that Real made at the beginning and Sarah Jane, because it's something I've been thinking about today. If this goes through, and we must stop it, we have to stop this happening because the effect of it is appalling. The chilling effect it will have on our trials, particularly in political and protest trials, which is where speech really does need to be protected. So I was reminded of a trial we had around 10 years ago about a political poem, and we compared the poem to something that might be more accessible, because the poem was quite radical, was quite was quite committed. We compared it with John Betjeman's Slough. Come friendly bombs and fall on Slough. It isn't fit for humans now. There isn't grass to graze a cow. Swarm over death. Now, in the new regime, if we're going to be clamped down upon, are we allowed to say that sort of thing anymore? Is that going to be taken out of speeches? And then I was reminded of the case of the Rotherham 12, who fought fascists in Rotherham 2016, who'd come into their community to attack their community, and they'd fought back. And so moved was the trial judge in that trial that in his closing speech, he compared it to Cable Street, what happened in 1936, where people put up barricades to keep out the police and to keep out the fascists and threw missiles at the police. Now, is that sort of thing going to be taken out of speeches in future for fear that we can't talk about history? We can't compare what's being spoken about with poems and history and with our culture. We can't talk about Bushell. This is the real danger, the chilling effect that it would have on political and protest trials in particular, but on all trials, as Sarah Jane has made the point. And so I just finished with this. We can stop this. I think there's an anniversary of Bushell's case coming up, and I think we should all celebrate it with supporting Rajiv in some sort of visual way. But I remember hearing Rajiv's speech at the beginning of the Grenfell inquiry. You couldn't have a better speech for that community and what happened to that whole community, burned in their flats for corporate, for cladding. A beautiful speech made by Rajiv Menon. He has always stood with the oppressed, and we need to stand with him now. Thank you very much.
Thank you very much, Matt. We've got 2 speakers left, and then we're going to wrap up with hearing from Rajiv himself very briefly. So can I pass now on to Jane Dighton, who's well known to most of us, I anticipate, a leading human rights solicitor at DPG Solicitors, again, a solicitor who's instructed Rajiv over many years. Jane?
Thank you, Pete. I've just come from the undercover police inquiry at which Rajiv and I have represented Dwayne Brooks and others over the last 10 years. And I'd like to tell you something about Rajiv as a barrister. And I'm going to start with a quote from Dwayne. He was reading Rajiv's draft opening statement to the undercover police inquiry. He's got it, Dwayne reflected. He's got what happened to me. He's got how I felt. He's got why it happened to me. And he's got the questions I want answers to. And he's put it in a way the inquiry will understand. I say that's Rajiv's brilliance as a barrister. In 1998, the Stephen Lawrence inquiry was due to start. Dwayne was 23 and suffering from chronic PTSD. What counsel could effectively represent him? I received a phone call from the legendary QC Courtney Griffiths. And he said this, he said, Jane, you must instruct Rajiv Menon. He's perfect, he's good, he's fearless, and his whole career in the community and as a lawyer has prepared him from this. We did instruct him. Courtney was right. Rajiv was perfect. Rajiv's warm, frank approach won Dwayne's trust. His incisive questioning unveiled the racism and incompetence of many officers, and his submissions swayed over the panel. And as we all know, the Stephen Lawrence report was a triumph. But as Deb alluded to, Rajiv did something more. He helped to build Dwayne's readiness to trust in the ability to work with the justice system and to make a difference. Dwayne went on to do just that as a local authority councillor and things like that. Rajiv has continued to represent Dwayne over these last 30 years. You don't instruct the same council over those years unless you have confidence in them. We do, in his rapport and his determination to represent his clients and his skill at explaining the interplay between his clients' interests, the law, and the rules of the court. Then came this prosecution of Rajiv. The consequences, as we know, go deep. For Rajiv's clients, they're Kafkaesque. In the spring, we had a conference with Rajiv about the undercover policing inquiry, which was due to start a 2-month hearing. I won't forget Dwayne's face when Rajiv walked into the room. Dwayne was profoundly shocked. The reason? Rajiv had shrunk. Rajiv was visibly battered by the prosecution. He had lost 25 pounds. Dwayne's reaction was empathy and support, and interestingly, disappointment that the judiciary could act the way it did. But it's unsettling. The defendant in one set of proceedings appearing for a client in another. Only last week, Rajiv had to excuse himself from the inquiry to attend as a defendant in his own case. It feels inexcusable that the DPP and some judges' actions have in effect intruded into Rajiv's professional obligations and put Dwayne into a position where he has to cope with the prosecution of the counsel of his choice. I hope the unfailing confidence in Rajiv by both his lay and professional clients of the last 30 years will give him some small measure of strength as he defends himself against this onslaught. Thank you.
Thanks very much, Jane. And finally, and not least, we have Asad Rehman, who is the director of Friends of the Earth. So Asad, over to you to complete the panel of esteemed speakers, and then we'll move swiftly on to hear from Rajiv finally.
Yeah, thank you, Pete, and yeah, just to echo the amazing contributions of such a panel of distinguished speakers. My name is Asad Rehman. I'm the Chief Executive of Friends of the Earth, the UK's largest environmental justice organisation. And for over 50 years, Friends of the Earth has defended both the right to protest and the integrity of our justice system, because we've always understood that the fight for environmental, social, economic and racial justice depends on our ability to be able to organise, to dissent and to hold power to account. And on a personal note, I've spent nearly 45 years campaigning for a fairer, greener and more just world. And central to my political journey was working at New Monitoring Project, where communities came together to challenge racist violence, police brutality and the far right across East London. And it was there that I first met Rajiv Menon. For more than 4 decades, Rajiv has remained unwavering in that simple principle that everyone, however unpopular or powerless, deserves fearless representation. And be it from the streets of East London to the highest courts in the land, his commitment to truth and justice and to advocate for those at the sharp end of injustice has never faltered. But we're here today because of what is at stake is, of course, far greater than the case of one exceptional barrister. And it's why Rajiv's case can't be seen in isolation. Over the last decade, as we've heard, we've seen an unprecedented assault on civil and political rights, the right to protest under attack, peaceful campaigners receiving extraordinary prison sentences, climate activists, anti-racist campaigners, and now pro-Palestinian activists have increasingly found themselves facing powers once reserved for the most exceptional circumstances. Today, anti-terror legislation is being deployed against people using non-violent direct action to oppose Israel's genocide and our government's complicity with it. And at the same time, the cornerstone and one of the oldest democratic safeguards in our legal system, jury trials, is under attack. This should concern everyone. Juries exist so that justice is not simply the mechanical exercise of state power. Independent advocates exist so that every person receives fearless representation. And protests exist because every democratic advance, from the votes for women, trade union rights, to civil rights, to environmental protection, was won because ordinary people came together to challenge unjust laws. And outside Parliament, of course, it's the greatest hypocrisy that we erase statues to celebrate people, whether it's from the anti-apartheid struggle, the anti-colonial struggle, or the struggle for the rights of women to vote, who, if they were alive today, would be in the docks and prison cells alongside those who have followed in their footsteps. And of course, this is not unique to Britain. And across the world, authoritarian politics is on the rise, and the far right, from the United States to India, from Hungary to Israel. And we've seen the same playbook: restrict democracy, attack rights, weaken safeguards, including attacking the independence of the justice system, including criminalising lawyers. The UN Special Rapporteurs have repeatedly warned that the UK's restrictions on protests, on policing powers and criminal sanctions risk breaching international human rights obligations. Civicus has downgraded the UK's civic space to that of Orban's Hungary, and international human rights organisations have warned of the chilling effect that these measures are having, whether it be on the freedom of expression, peaceful assembly, and political participation. And history teaches us that rights are rarely abolished overnight. They are eroded piece by piece, one protest law, one exceptional prosecution, one restriction on legal defence, until what was once seemed unthinkable becomes routine. And that's why Rajiv's case really matters, because if lawyers can't defend fearlessly, justice is diminished. And if juries cannot exercise independent judgment, democracy is weakened. And if peaceful protest is treated as extremism or terrorism, then democracy itself is placed in jeopardy. So we defend Rajiv Menon, not simply because he is a dear friend or a valued colleague, but because this is an unprecedented attack on all of our rights. That's why we defend the independence of the legal profession. It's why we defend the right to protest, because democracy cannot survive without dissent. And we cannot defend the trial by juries because justice, without defending trial by jury, because justice belongs to the people, not simply to the state. And we defend civic space because without it, there can be no meaningful democracy. The struggle for justice, racial justice, Palestinian rights are not separate struggles. They're united by a single principle, that ordinary people have the right and responsibility to challenge injustice. And that is a principle that has always frightened authoritarians, and it must continue to inspire all of us. Thank you.
Thank you very much, Asad. That's, again, very powerful way to finish us off. And can I just, before I bring Rajiv in finally, can I just say that if you want to follow the facts of Rajiv's case, on X, there's Defend Our Lawyers, which has regular updates about it. And of course, there are many things that we can all do. We can attend whatever happens next, the trial if it is. We can write about it. We can raise it wherever we can. We can write or talk to our MPs or lords and peers. But please, as Gareth said earlier, don't be a spectator. Please get involved. Finally, can I just thank people who did organise this, because it wasn't me. Somebody thanked me before. It was Mira Hamad at Garden Court North and Michael Gould, helped by a number of other people. So finally, Rajiv, I know you want to say a few words. So finally, over to you, and thanks everybody for attending.
Thank you, Pete. Can I start by thanking Pete and Mira and Mike and anybody else who was involved for organizing this incredible event, and all the barrister chambers that co-hosted it and the solicitors firms that sponsored it. Can I thank all those who have spoken today, many dear friends and colleagues for their incredibly kind words. Can I thank all those who have been supporting me during the past few months. These are unprecedented times. You know who you are. There are simply too many people, too many individuals and organizations for me to start naming them today. I would be here forever. What I do want to say is that I've been completely overwhelmed and humbled by the enormous support I've received from so many people, lawyers and non-lawyers, including complete strangers who have written to me or contacted me online. As far as where we go from here, Pete intimated the most recent position at the beginning of the meeting. I'm appealing against the orders made by 3 High Court judges. We filed those grounds on Monday, and we anticipated that, given part of that appeal is the very order that led to the trial that I'm due to face next week, that the trial judge would vacate that trial. But not long before this rally began, she informed us that she was not going to be vacating that trial. So as things currently stand, the trial proceeds on Tuesday. But we have now written as a matter of urgency to the Court of Appeal because it simply doesn't make any sense. And we're hoping that the Court of Appeal will tomorrow morning inform us that my trial, currently fixed for Tuesday, has been vacated and postponed to sometime in the autumn. If you want to be kept updated about what's going on, I mean, obviously, many people will be able to fill you in, but we're creating a web page on my contempt case, which will be live on the Garden Court website in the next few days, and that will provide all the necessary information to keep everybody updated. Finally, it would be remiss of me not to acknowledge the Filton 24, the incredible young people who risked everything, to speak truth to power and to do what they thought was right when they engaged in direct action against the Elbit Systems factory in Filton. It was an enormous privilege for me to represent Charlotte Head together with Simon and Kate. We fight on for her against the draconian sentence that she received from the very judge who instigated the proceedings against me. And that battle will continue as long as it needs to continue. So thank you, everybody, finally, who attended this rally, this webinar today. I hope I can count on your continued support going forward. I'm truly grateful. And as I say again, I've been overwhelmed and humbled by all that support. So thank you all very, very much. Mira, I think, has just posted on the chat the petition, and I'm grateful to Netpol and Defend Our Juries for launching that. I hope everybody will feel able to sign that. Thank you, Pete, and thank you, everybody here today.
Thank you so much, Rajiv, and we all stand with you. And with that, everybody, thanks very much for attending, and that's the end of this event. Thanks very much.